So today we're going to be talking about earnest money deposit. How much earnest money deposit do you need with your offer? How do I get that earnest money deposit back? Is earnest money really that important in today's market? Is earnest money considered consideration? These are great questions. Let's get right to it. So right out the gate, I'm talking about the state of Virginia. Earnest money is handled differently in different states. Everything's state regulated with real estate. So for this video, I'm talking about Virginia earnest money deposit. So how much earnest money deposit should you be putting down on your offer? Well, most realtors would tell you, and I agree with it, it's going to depend on how much the home is and how much you're willing to put up, because earnest money isn't consideration. Earnest money is good faith. Here's how interested I am in your home. I'm willing to put this much money in escrow while we dance through this whole contract period until we get to the closing table. And if I default as a buyer, you're going to get to keep this earnest money deposit. At least that's what the contract says. So, thinking about earnest money deposit and how much to put down, that is your thought process. It's for peace of mind for the seller and making them feel like you are a serious buyer because you're willing to tie up your money until we get to the settlement table. And you're willing to give them this money in the event that you default on the ratified contract. Lots of things to think about with that. So, how do you get your earnest money back? Great question. It really depends on how the offer is written. Typically, you would see 4 ways for you as a buyer to get your earnest money back. Obviously, the first way is as a credit at settlement. So at the closing table, your CD, closing document, would show how much earnest money you put down and how you're going to be getting that back as a credit towards either your closing costs, prepaids, other concessions that you have to pay at settlement, or towards a credit towards the price of the home. So you would see that on a CD typically as a credit back. That's obviously the number one way and the best way you as a buyer are going to get your money back. What's the second way? Well, the second way is to draw up a release agreement. That's where the deal didn't actually go together after it was ratified. Maybe you had some property inspection challenges, or it didn't appraise, or your financing fell through. Something that the contract is allowing you to get out of. That's not default, all right? That's not something that you caused or a choice that you made that goes against the contract. That's something that's being allowed by the contract, a contingency, right, that is controlled by either you or the lender. And so based upon that, you should be able to get your money back. That's what this is talking about. So a release agreement would need to be signed by both the buyer and the seller, and an agreement to how much earnest money the buyer's getting versus how much money the seller's getting out of that earnest money deposit. Now, in the truest sense, if it was a true contingency and you had the ability to walk and the contract read that you're going to get your earnest money back in the event that you choose to walk away based upon this contingency, then you should be getting 100% of that money back. Once again, it depends on how the offer and the ratified contract were written, okay? But that's the number 2 way. So first was a credit at settlement to you, the buyer. Second was a release agreement that is going to just go to you as the buyer. The other part of that release agreement, though, number 2, is what if you defaulted? Then the seller would do a release agreement saying, I'm not selling you this house, I'm terminating this contract, and I want the earnest money deposit. The challenge with the release agreement is both sides have to sign it before any money can be distributed, because that money is being held in escrow. The real estate companies have no control over that money being dispersed until there is a release agreement signed by both sides, right? So we know number 1 is a credit back, number 2 is a release agreement, either to the buyer or to the seller. The third way is by a court order. That means that you as the buyer might have to sue the seller to get your earnest money back, or the seller might need to sue the buyer to get that earnest money. Because if neither side is willing to sign the release agreement, then that money's going to just sit in escrow and sit in escrow and sit in escrow. The fourth way is if one side doesn't respond at all. So the buyer does a release agreement and he gets no response from the seller. Now, depending on how it's written in the contract, the buyer can write a letter to the seller requesting that money, and after X number of days, typically 90 days, if there's still no response, then the buyer can use that document that as a certified letter with no response to be able to pull that money out, as well as the seller could do the same. Once again, depending on the verbiage in the contract, you need to check it. And if you're outside of Virginia, you need to check your state laws to see how that pertains to you. So those are the 4 ways that you would see getting the money dispersed. Not necessarily going to the buyer, not necessarily going to the seller, but how the money is dispersed. Let's talk about what the money's doing while it's sitting in escrow. Well, it's sitting in an escrow account. The seller can't touch it and the buyer can't touch it, and we know that. But let's say a real estate company's holding that money in a specific designated account that is only holds earnest money deposits, right? That's the law for a real estate company or a law firm or a title company, whoever. It has to be a specific account just for earnest money. That earnest money can be accumulating interest. Now, obviously, in today's world, interest rates aren't that great, but it's still accumulating interest. Who gets the interest? The company holding the money. And they get the interest for as long as that money is sitting in the account. So think of how many people maybe put a $500 earnest money deposit and they don't get the deal doesn't go through, and maybe the other side doesn't sign the release agreement, but they've said, we're not going to release it. So they've communicated back, we're not giving you your earnest money. That money just sits in the account. And if one side doesn't sue the other side, it just sits in that account. It's one of the great ways that a real estate company, a law firm, a settlement company can actually make some income by having all of this money sit in an earnest money account. But just make sure that you're aware as a buyer, you don't make any interest on that money as it sits there. And that is definitely drawn into the contract so that you can see who's holding the earnest money deposit and how it is handled. Okay, so just one little tip there, if you were curious as to what happens to the money that's growing based upon the money that's sitting in the account. Well, it stays with the firm that's holding the money. So the final thought process on earnest money for this video is, how important is it? Is it important enough where it's going to get you the house? Well, it's not considered consideration in the eyes of the law of a legally binding contract. Consideration is the purchase price, because the buyer gets that money back if he buys it as a credit. It's not added to the price of the home, which would be consideration. So how important is it? Well, it's extremely important if you have a seller that hasn't been educated on what earnest money is and what it isn't, right? It's not consideration. It's not very important if a seller understands, earnest money is just peace of mind. It's there to make me feel good. The only way I'm going to get it is if I sue the buyer because of defaulting, and I would probably still have to prove damages in a court to show that I should get that earnest money deposit. So the biggest thing that I can share with you is make sure that you're educated as a buyer and a seller as to what the earnest money is and what it isn't. It is peace of mind. It is there to make the seller feel good that you're a serious, ready, willing, and able buyer. As a seller, it's there as a tool to say these guys are serious and they're ready to buy. There is one key component, though, that can make the earnest money a little more special, and that's making it non-refundable, meaning that no matter what happens, this $1,000, $10,000 earnest money deposit, the seller is going to get to keep it. So if you've got this contingent on a home inspection and you decide to walk, he still gets to keep your earnest money deposit, right? The only way you're getting that earnest money deposit back is as a credit at settlement, okay? The other ways of getting it back go out the window. because you've decided to make it non-refundable, meaning you are tied to this contract at least for that earnest money deposit. You might still be able to walk away with contingencies or even default, right? But you're not going to get that earnest money deposit back. So there's no sense in filling out a release agreement, right? You're guaranteeing I'm buying this house, and if I don't, you get to keep this money. One of the other key components you need to remember is if the earnest money doesn't cover damages that the seller incurs in getting this house ready for you to buy. Let's say that the contract calls for new carpeting, so he puts new carpeting in. If he can convince a court that that new carpeting was put in specifically because of you, once again, I'm not a lawyer, but you would think that those might be damages that he might incur and that the court might give him that exceed how much the earnest money deposit was. So there's a lot of stuff to remember there, but the number one thing to remember is it is not consideration. The sale price is consideration. It is there 100% for peace of mind to make the seller think that you're a ready, willing, and able buyer and that you're willing to put this money up. Making it non-refundable definitely adds some value to that. All right. I hope you enjoyed this video. I know it wasn't too in-depth, but it's definitely got a lot of points there that as a buyer or seller you need to pay attention to, get more education. Please check out my other videos. I have a whole playlist of videos specifically to real estate for buyers and sellers. Please be sure to subscribe to my channel, like my channel. It really helps with my search engine optimization and getting the word out. I'm just trying to educate you guys. If you are a seller, though, we do offer RedefiFlatFee.com, which is our flat fee listing service, $5,500. Doesn't matter what the price of the home is. Check us out. We are back on a regular basis. I'm putting out about 2 videos a week educating buyers and sellers. Stay safe out there. Make it a great day.
Are you tired of paying high commissions when selling your home? With RedefiFlatFee.com, you have the option of paying a flat fee instead. Located in the Hampton Roads area of Virginia, we offer 100% full-service realtor firm services at a fraction of the cost. Save your equity, save your money with RedefiFlatFee.com. Visit our website today to see how much you can save by using a flat fee real estate company. Take control of your home sale and start saving now.